There are certain farmers' rights as per the Act. Now, the Indian Act is unique because apart from the rights that are granted to breeders, there are certain rights that are inherent to the farmers and that have been specifically granted under this Act. A farmer who has bred or developed a new variety shall be entitled for registration and other protection in a like manner as the breeder of the variety under this Act. A farmer who is engaged in conservation and use of genetic resources and wild relatives of economic plants and the improvements through selection and preservation shall be entitled to a recognition and reward from the government, provided the materials so selected and preserved has been used as donors of genes in varieties registrable under this Act. The farmers shall also be entitled to save, use, sow or resow, exchange, share or sell his farm produce including seed of a variety protected under this Act, provided it does not apply to branded seeds. And branded seeds mean any seed put in a package or any container and labeled in a manner which gives an indication that such seed is of a variety produced or protected under this Act. The number of registration and applications received under the Act, we have a descriptive analysis of it. Until August 2015, there were 1424 public applications. Private parties have made 2954 applications. Farmers, which form the majority of the applications, have made 5693 and individuals have made 2 applications. The total number of certificates issued by the Plant Variety Protection Authority is 1870 until August 2015. These are the most recent statistics available in this regard. Benefit sharing under the Plant Variety Protection Act is one of the important pillars of the legislation. Benefit sharing, however, is only for Indian citizens and organizations. Breeders can oppose the claims regarding benefit sharing. The Plant Variety Protection Authority shall decide the quantum of benefit sharing. The amount of benefit sharing will be deposited in the National Gene Fund. The importance of having a benefit sharing requirement under the Plant Variety Protection Act is precisely because certain varieties have been traditionally cultivated and the breeders who rely on such varieties are required to make payments regarding the benefits that they have derived from using those varieties for further breeding. Now, there is a very recent case that exposes how the breeders have sought to evergreen the protection available under this Act. In Maharashtra Seed Corporation, Monsanto and others versus Union of India, the Delhi High Court in January 2015 had a very important question to answer. The question was if hybrid variety already registered and whether parental lines involving those, whether they can be registered under the Act as a new variety. The Delhi High Court denied registration of parental lines based on the argument that such a registration would allow extension of protection, overall protection available for the variety. The Delhi High Court said if the provisions of section 15(3) of the Act are read in a manner as suggested by the petitioners, that is Maharashtra Seed Corporation, the effect would be to extend the period of protection many times over. In the first instance, a breeder would get protection in respect of hybrid variety, and assuming that there are 2 parent lines, the breeder could just before the expiry of registration certificate in respect of a hybrid variety, register one of the parent variety and thus extend its period of exclusivity for a further period of 15 to 18 years, because protection of even one parental line would practically ensure exclusive rights in relation to the hybrid variety. In the same manner, before the expiry of the registration period of the parental line, the breeder could register the other parental line as a new variety. In this manner, a breeder could extend protection for a period up to maximum of 45 to 54 years instead of 15 to 18 years as contemplated under this Act. Clearly, this is not the legislative intent of the Parliament. It seems the reasoning behind this decision is that the court was trying to avoid overlapping of protection by virtue of seeking continuous protection on parental lines before the expiry of protection for existing varieties, which the court said was not possible under the act. There are certain rights, there are questions relating to how to determine infringement, and there are remedies available under the act. The rights granted under the act are to produce, the exclusive rights to produce the protected variety, the exclusive right to market and sell the variety, the exclusive right to distribute the variety, and the exclusive right to import and export the variety. Now, in case of essentially derived varieties, where the essentially derived variety from a protected variety, then authorization required from the breeder of the initial variety. So, hence the right is subject to, in case of essentially derived variety, is subject to the authorization from the breeder of the initial variety. Infringement amounts to, in as per the act, any act of selling, exports, imports or export of a registered variety, or sells, exports, imports or exports a variety deceptively similar to the registered variety. The relief that is granted under the act is injunction, and then you have an option of either accounts for profit, that is sharing of the profits, or damages. Finally, there are certain exceptions and limitations granted under this act. The acts that are not to be considered as infringement primarily deal with the rights of the researchers. Now, in case of researchers' rights, the use of a variety for research and experimental purpose is perfectly allowed, which means that these acts shall not amount to infringement. Secondly, the use of a variety as an initial variety for the creation of a new variety is absolutely allowed. The repeated use of a variety for commercial production of a new variety is, however, not allowed without authorization of the breeder of the registered variety. There are provisions concerning compulsory licenses, which is available 3 years after the grant of the protection, that is after issuance of the certificate, on account of unaffordable pricing and unmet demand. To summarize, let us briefly recapitulate what we have done through the whole module. We have looked into the objectives of the Plant Variety Protection and Farmers' Rights Act 2001 in India. Among the important objectives is to incentivize the creation of new plant varieties and to incentivize production of seeds in the country. We have looked into the international regime for protection, primarily the TRIPS agreement requirements under Article 27.3, and also the Union for Protection of Plant Varieties, to which India is not a party to. We have discussed the differences between the 1978 and the 1991 regimes of UPOV. We have also looked into the requirements of registration in India, which is novelty, distinct, uniformity and stability. We have also looked into how and what kind of varieties are acceptable under the act, that is the requirement, those varieties which are novel, which are extant varieties, which are farmers varieties, and which are essentially derived varieties. We have also looked into the nature of applications made by different breeders, private, public, individuals and institutions. We have looked into the requirement of benefit sharing under the act and how benefit sharing is to be done, and adequate amount of benefit sharing has to be made by the authorities, the quantum to be decided by the authorities under the act. We have looked into the issues of infringement remedies under the act and how infringement is defined and what rights are granted. There are also certain limitations and exceptions granted under the act, precisely for researchers, and also provisions concerning compulsory licenses. Most importantly, one of the fundamental pillars of the act is the farmers' rights that are provided, when the most important of such rights is the farmers' right to save, resow the seeds for further production, except where the seeds are branded. So, overall, the Plant Variety Protection and Farmers' Rights Act is aiming to balance the incentives for the breeder with the traditional rights that farmers have in relation to their plant varieties. Thank you one and all.